to avoid conflict of interest and the appearance of a conflict of interest in connection with the duties as a member of this committee to study regulatory change and in the North Carolina State Bar. Any member who's aware of conflicts should bring those to our attention. Anybody have any conflicts they wish to disclose? If not, we will go ahead and get started. This is going to be primarily a discussion meeting. We've learned a lot of information. I think it's time to start in. As you saw from the proposed agenda, we're going to really focus on digging into the idea of limited license paraprofessionals and talk about what that might look like. I guess the one administrative matter is approval of the minutes from the May 26th, 2001 meeting. Do I hear a motion to approve those?
So moved.
All right, thank you, Jeff. And Steve, did I see you seconding, Steve? I saw that thought forming in your mind. All those in favor say aye.
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 It seems like unanimous approval of those minutes. So we're going to jump in. Again, we covered a lot of ground, and I think our thinking in terms of how to proceed is let's start with the one that seemed to generate the most interest and the most positive votes on the survey, see if we can reach some decisions on that with the idea of reporting back when the Issues Committee meets in July, not too far away now, and happily in person. So that's my goal coming out of today is let's have this discussion around this, talk about pros and cons and issues, and do a report. We're not going to finish our committee's work. We've got a number of other things to think about in future meetings, including the idea of a regulatory sandbox and some of the other proposals. We had a long list, but I think we just need to chunk them out and dig into those. And Brian, do you want to set up some of the issues? I know you've listed some in the agenda, maybe set the table in terms of some of the things for us to talk about as we dig in.
Sure, absolutely. So just to kind of go through very briefly the materials that were sent out, and this is really to Mac's point that Mac's request last time, kind of a description that you'll see at the outset right after the minutes in the agenda. There's a description of these different ideas, these different topics. I know we were kind of talking about a number of different things. There's a lot of overlap, and so some of the survey responses, as our discussion evolved last time, we realized that something like the liberalization of the UPL rules is a great topic to discuss. But exactly what are we talking about? Are we talking about changing those rules with regards to permitting a limited license, or are we talking about something else? And so that's where I tried to clarify exactly what we could talk about through that description or that summary sheet that you find in the materials. Noticeably, as I was going through this effort to give some sort of description, I realized that the topic of non-lawyer ownership was really covered in the alternative business structure description, as well as fee sharing with non-lawyers. While not an ownership aspect, but it's still kind of a sharing in whether it's the fee, the profits, whatever the structure may be. So you'll see that non-lawyer ownership is listed there, but that it is struck through. So that is something just to kind of be aware of. But generally speaking, you have, I didn't include a description for limited license for non-lawyers. I think we're all aware of what's going on there, but you'll see court navigators, those alternative business structures, the overall regulatory sandbox, liberalization of those UPL statutes and rules with regards to other specific ideas that we've seen in other jurisdictions, including something like, I believe Arkansas, if my memory serves, has a definition of the practice of law that's really tied to not just representation of a client, but doing so for some sort of financial or personal gain. And so it kind of, I guess, presumably excludes some type of pro bono activity, or that I know we talked about with the Ontario folks, how they had this system before where there was kind of I think the person described it as a friends and family sort of exception to their unauthorized practice rules, which was a new idea for us to think about. But nevertheless, that's really what that particular topic is going into. And finally, rounding off with alternative admission to the bar, which I think we really didn't discuss much. We've noted that some jurisdictions have other processes to admit folks to the bar. And this is where we start to see, well, not really just here. There's a lot of places where we see a lot of overlap, but this is one of those, because really what we're talking about with the limited license is an alternative admission to the bar in a way. It's admitting some folks to the bar in very specific areas for particular purposes. The alternative admission to the bar topic is that's listed there is much broader in the sense of perhaps people should be able to sit for the bar exam without going to law school, or kind of the opposite side of the coin. A lot of folks, especially last year, were arguing for a diploma privilege and things of that nature. So those topics are still out there. Looking at the, and I'm going to go ahead and share my screen here. There's a chart that I included in these materials. And I want to make sure you all are seeing the spreadsheet that I have here. So this is just kind of a very brief overview of the different active limited license programs that are out there in the United States. You have Oregon there with a question mark because the Oregon Supreme Court has approved the formation of this license, but they have not yet done so. They haven't finalized the structure. It has not gone active yet. So if that goes active while we're still meeting and discussing this, then I'll be sure to update you all. But generally speaking, when we kind of focus our attention on limited license, then wanted to kind of get some of the key aspects. And again, I don't think this meeting in particular is to kind of figure out all the specific details of how that license would function. But I think we did want to talk about things like what sort of statutory amendments would need to be made, particularly with regards to the unauthorized practice of law. Is this something that is going to be a recommendation for a permanent change, the way that Arizona and Utah have put in place to just actually create this license, and it's going to be indefinite unless that law itself is changed? Or is it a pilot program, the way that Minnesota has going on right now for the next 2 years? What areas of practice? I know that's going to kind of harken back to last subcommittee meeting with regards to the legal needs assessment. And what is the scope of the license? Is the recommendation that somebody with this limited license can appear in court? Does the person, or maybe perhaps not allowed to appear in court, but can act in other advisory roles? Does the person have to act under the supervision of an attorney? Things of that nature. Those are just kind of, I guess, different key parts to this discussion on what the recommendation would be as the state bar continues to look at this particular idea of a new limited license for non-lawyers. So with that said, that's my very, I guess, not as brief as I intended description of those materials. But I think, Mark, we wanted to kind of start off talking about the statutory considerations. Before I jump into that, though, Mark, I don't know if you want to take this in a different direction.
I guess, yeah, I think that's a good introduction. Here's what I envision, right? This committee is not designing a limited licensure program. That's not our mission, right? As you recall from when we started a year ago, we want to tell the issues committee what areas we think are worth pursuing. So, but I do think we can do more than just a limited licensure. Yes, I think broadly speaking, it would be helpful, since we spent a year studying it, for us to make some recommendations around broad questions like the ones that you just saw on the screen. Is this a permanent change or a temporary change? Is this going to be all practice areas or limited practice areas? And what generally the scope? We don't need to spend time debating, what the training requirements would be, or, some of the other logistics stuff. Clearly, that's going to be the work of a new committee. But I think if we can provide some parameters, since we've spent time studying it, that's helpful. And obviously they can decide where to take it from there. So that was my thought. I guess, Brian, the other thought I had in looking at that screen, we didn't include Washington State. I guess that's because they've ended their program. But that's correct. To me, another potential model to think about in terms of their program, since, they did go through the implementation and actually had folks. But I think that's right. Let me do this, Brian. I know we want to talk about some of the statutory issues, but before we get there, let me get input from anyone on the committee around kind of the structure and thoughts. We've done a lot of presentations. I really want today to be more discussion. So chime in on that structure. And if we don't have any comments, then Brian will go into some of the authorization, practice of law issues, but let me get thoughts from folks.
I'll try.
Yeah, go ahead, Mac. Mac first, then Colin.
I'm not sure I understand your question. What are you looking for comments on?
I wanted to get, I guess, thoughts on the approach. Make sure you feel like we're on the right track before we just jump in and look at some of the statutory issues in terms of, making that kind of recommendation to the Issues Committee and feedback on that approach.
Are you expecting that the Issues Committee will then hand it back to us or someone else to take it the next step?
It's a great question. I mean, I do expect, my hope and expectation would be the Issues Committee would say, yeah, this sounds like an idea worth exploring, and then form another committee. Maybe some people will carry over from this committee to that new committee, but a new committee to actually work out the nitty-gritty and give the state bar something that they could actually vote to act on. So
I'll admit that I was thinking we would take it a touch further.
okay.
We have now put a year of study and thought into this, and I would hate to waste the momentum and background that we've got by disbanding this and handing it to a new group to have to start fresh. It seems to me that we could go a little beyond just a bare bones recommendation, and on the things that we have an opinion on, give them some thought about where we are and how we got there and why we think that might be an acceptable approach. So it doesn't look like a half-done job for them, that it really does say, this could work and here's why.
Good thoughts. Colin, did you want to add something to that?
It seems to me that this concept really has had its gestation period, its birth, from the unavailability of legal services to folks. And it seems like that we might want to look at what are the areas where we view the greatest need, and then maybe even make some suggestions as to those particular areas for, as Max says, take it a step further, but to take it, if it's family law, if it's housing, if it's immigration, whatever those we feel like those are, and then perhaps if we at least make some recommendations, maybe the state bar, along with the Bar Association or some other affinity bar groups, can look at the mechanics of how do we minimize the risk, how do we ensure the proper regulatory oversight, and some questions like that. But I think we need to give maybe a push in a direction that we think it ought to go, because we really have dealt with this issue and looked at a lot of other things and have the benefit of a lot of information that probably very few North Carolina lawyers have.
Warren?
Just to add to what has been said and thoughtfully said, I wonder if the people receiving the information, Mark, that you will give them, that we produce, won't ask themselves and each other, should the group that has spent a year doing all this work and processing and plowing this field not be the group to go to the next step and present some concrete recommendations? And if they would say that, should we be prepared as a group, or you as the leader of this group, to respond to that question as well?
Thanks. Ashley? Go ahead, Ashley Campbell.
I'm sorry I was late. I had such a hard time finding the Zoom link, so I apologize to all of you. The first thing I want to say is how informative I have found all of this to be. I work in the area of legal services to low-income people, and I still learned a tremendous amount by being involved in this work. Over the last 6 months, I sit on the Equal Access to Justice Commission, the Chief Justice's Faith and Justice Alliance. And so I have repeatedly seen the presentation of the legal needs assessment, along with Mary Irvine and others who are on all of those calls with me. We've probably seen presentations on that at least 4 times. It is undisputed that we are not meeting the need of the people in this state in terms of legal services. And I believe that we are at a crisis point. What I personally, Ashley, would like to see is us provide leadership on this issue for us as lawyers to lead in articulating the need, and that the need to us as lawyers is unacceptable, that it is unacceptable for people who want to access the justice system to not be able to, that it undermines our justice system, and that we believe that changes need to be made to address the issues, and that we recommend that these changes be made, and that we develop a plan for doing it. And some of you who know me know, I used to be a lobbyist. I used to lobby at the legislature. I understand how that process works. I would love to be involved in that process around this issue and would volunteer my time to do it. I'm not afraid of it. And, I think it's time for us to say, this is not acceptable and we need to change it. And for us to decide what the 3 issues are or whatever that we want to pursue, and to see if we can really make a dent in this problem. Thank you for letting me share that. I just really want to see us lead as lawyers.
Nope,
If we don't do it, who is going to do it?
I think it's very well said. I see Matt clapping in the background. I agree. I see a lot of nods. Ashley, thank you for sharing. That's very helpful. This is helpful to me. Other thoughts on the process? Maybe Brian, I know we needed at some point talk about some of the legal issues, but I think given that those comments, I think I'd like to let's jump to the areas where we think we want the areas of practice issue, because I think that's one we've had a lot of discussion on. And it seems really timely since we just had the whole access to justice presentation. We spent a lot of time learning about where those needs are. And we may all be in agreement, but we may not. I'm very interested to see, what as a group, and it's really, as I view it, it's a 2-part question. One is the limited license paralegal able to practice in all areas? And yes, no. And then if the answer is not all areas, the answer then becomes what areas? And do we list out, what those areas of practice should be? I think that's kind of a fundamental question. And I totally agree. That's when we should provide our thoughts and guidance on. So with teeing it up that way, let me just, again, we may all be on the same page. We may be different, but that's why we're in a committee. Let me ask the first question. Do we want to limit it to certain practice areas? What do we think? Who wants to speak either for or against some practice specific limitation? Mac, I saw your hand first.
I think we should. The issue is getting the support of the people that we will need to support it later on. First, the state bar, then other groups like the Bar Association, and finally the legislature. And I think if we go in with a shotgun as opposed to a laser, we're going to be dead on arrival. We need to pick those things that the data prove are the most needed services for underrepresented people. Let's keep it as narrow as we can in hopes of getting the prize.
Thanks, Mac. Other views, Steve Robertson.
I agree with Mac. We have met the enemy and it is us. The hue and cry from the bar is going to be loud. In looking at Brian's brief chart, I would say that the Minnesota approach is one to look hard at because it doesn't cut lawyers out of a job, which is what we're going to hear plenty of. And it, I think, addresses the areas that, and I'm a family law practitioner, and I can tell you for sure, I would feel no job threat from getting non-lawyer secondary tier providers involved in the family law picture in the state. And, and of course, we are the bar, but we're always keeping in mind, as Colin points out, that we're here for the public. There's no argument that services, legal services, and people's ability to get them and afford them are at a crisis level. And these are the areas that it seems to me you could get started with and not, if you set up a structure that would sort of minimize even the perceived threat to lawyers, that you'd maybe get something off the ground a little easier than other approaches.
Thanks, Steve. I see Marcy, I see your hand.
Hi, everybody. So when we're talking about family laws, and I think the report points out custody and domestic violence, are those the two areas? We're not talking about, dividing retirement benefits and all those more complicated. Are we talking, when we're talking about practice areas and specifically domestic, are we talking about custody and domestic violence?
I've spoken before about custody, Marcy, and you know how the statute's structured, that everybody's got to get to mediation. And in order to get to mediation, you've got to file a lawsuit. And, is there some other structure we could put in place to just get the parties? No lawyers are invited to the state provided mediation. Is there some way to streamline that or have a secondary provider that could get people who are disagreeing over child rearing to the table and try to work something out? So that's the one area that I think about.
Yeah, the pre-litigation mediation, I think that's a great idea. But you're saying that they would have a paraprofessional with them at this pre-litigation. What about after lawsuits?
Well, they don't now. Of course, now you can't get there before the suit is filed, right? But I don't know, those DB forms are so bloody confusing. I spend hours pouring over them, getting ready for a hearing whenever I look at them. But to the extent.
Let's do, I might just suggest, I do think, to me, it's kind of I think we're maybe forming a consensus that we want to limit it to certain areas. Then I think the issue is what areas, and then to Marcy's point, what services can they provide in those areas? So it's kind of a triage approach that I do think is worth discussing. Let me see though. Does anyone feel like it should not be restricted to any practice area? It should be a broad. They can practice in any area view. Does anyone want to argue for that approach? I see Jeff Kelly. Go ahead, Jeff.
I'll maybe not quite that far, but here's kind of to blend the two conversations. One area of concern I have is the reason, in my opinion, that Washington is no longer on the paraprofessional list is because they didn't go far enough in terms of what they allowed their certified triple LTs to do. And so as we're doing this, I understand that we have to thread a needle here. We're dealing with some political considerations that at the end of the day they're very real, and I'm not naive about them. But whatever we produce, we have to keep as a touchstone that we are working for the public, not necessarily the bar in that sense. And whatever we're doing needs to go far enough that we candidly push some boundaries. So yes, I think it makes sense to focus, but I don't know that I would advocate for limiting, if that makes sense.
No, thanks, Jeff. Alicia Kernodle, you're our paralegals on the committee. I'm interested in your thoughts and perspectives on this question. Go ahead.
Good afternoon, everyone. Phenomenal Hodges. So, of course, family law is definitely a huge area. It is the highest demand, unfortunately. You've also heard us mention landlord-tenant issues. And we also have the educational component when you have parents that are trying to get the due process complaints filed and following through. That can be expensive and very tedious and time consuming, and most parents are not familiar with that process as well. So your landlord tenant, your family, your education, and as Jeff said, you can't say limit certain things because it may require you to go beyond, because each case will vary and it will require something different. And if you limit too soon or too exact, then the limited licensed technicians will be ineffective.
Thanks. Any other? Go ahead.
Joshua Malcolm.
Joshua, yes. Sorry, I can't see your hand because go ahead, Joshua, jump in.
I think it's fair to say, from the tone of some of the questions I've asked in the past and comments I've made, there may be a rightful belief that I'm on the side of limiting, if anything. And with all due respect, I understand the most recent comment, but I think going too far, too fast, irrespective of what's happened in other jurisdictions, is beyond what may allow us to get buy-in. And Jeff, you used the word political. I would couch it a little different. I mean, this is, talk about moving people's cheese. This is going to be a big step forward. And I would suggest when we take that step, we need to take a logical step that's achievable, that if there's difficulties or unanticipated consequences, we have an opportunity to dial it in. And with that said, I would suggest I'll use the word limited. I would suggest it be limited to certain areas. That's my feedback, Mark. Thank you.
Thanks, Joshua. Mac.
I like the list from Minnesota, but I would probably, on Alicia's recommendation, probably add the educational piece, the student plans. I don't think that's going to raise a lot of hackles. But the kind of thing that I would not put on the list is something like immigration. I'm absolutely convinced that there is a need for that, but it's a lightning rod that might take the whole thing down.
Thanks, Mac. So I think we've heard several views. I want to, we haven't done a lot of voting. I'm not sure we need to do a lot of voting. I think, are there other people in addition to Jeff that, Jeff Kelly, that would support that would be opposed to limiting it to certain practice areas? Let me ask it that way. I think Jeff raises some good points about scope, and I do think we want to be sensitive to the fact we have to get enough people engaged and enough services provided to make it big, right? We don't want to do all this and have 50 people now go through and become limited licensure. I agree with you, Jeff. It needs to be big enough. I guess my thought, we focused a lot on legal needs. That is part of our mission, is to how do we address the access to justice gap. There really isn't an access to justice gap. For example, in large scale merger and acquisition work, we don't really need limited license professionals. So I don't know that we, have a need to change some rule to say that, that the paralegal at Womble can now do more than they could do before, right? That's not really addressing the need that we've been learning about. So I think starting with some identified areas may be a more achievable and logical connection to get that buy-in. And again, if it's successful, I think expanding out makes sense. Sounds like that's where we are as a group. And I think then the question is, what are the areas? Brian, maybe you can we've had Steve and Mac reference Minnesota. Can you put that back up in terms of, and I see your comment, Ashley. So it sounds like Ashley would be a vote for a broader thing. I see that.
Yeah,
too.
well, and I was going to say, I've got, let me see if I can actually get this up here. I've got the Minnesota rule. Tell me if you can see this. I'll try to zoom in, or hopefully it's somewhat legible. This is the Minnesota rule on supervision for authorizing particular practice in Minnesota. And I think that the chart, I fear that my I guess decision not to include this entire paragraph in that chart, I don't want that to mislead people. There is a limitation in Minnesota, or at least a lot of kind of picking out different parts. You can see there in paragraph B that it's talking about that essentially under the supervision of an attorney, someone who has this license can provide advice to and appear in court on behalf of clients in family law cases, but such services shall be limited to advice and hearings related to child support modifications, parenting time disputes, and paternity matters. Now it goes on, it says that, with the approval of a supervising attorney, these paraprofessionals may also appear in court in family law cases for these different purposes: default hearings, pretrial hearings, informal family court proceedings, and things of that nature. So they do get very specific in their description of exactly what they mean when they say somebody with this license can engage in a family law practice. This is where I feel like this comes down to almost like a subject matter expert sort of discussion of exactly what service is needed from that legal needs assessment, what sort of I guess mission bleed occurs with those specific needs, because to everyone's points, both Jeff and Kernodle talking about how things can change, and are you potentially putting more of a burden on somebody who is getting assistance from somebody with this this limited license, and suddenly they have to go to an attorney because one thing happened, one additional step was required of a particular proceeding, and now it's a different ball game, and maybe that person doesn't get those legal needs. And I think that sort of thing probably needs to be analyzed on really kind of a micro level with some subject matter experts to really figure out the parameters. But there are those types of limitations in Minnesota for whatever it's worth. And you'll see the same things are in Utah. Arizona, if my memory serves, Arizona is much broader. I think they have some, they might reference some things that, like Marcy, to your point, I don't think that folks in Arizona can, with their limited license, can engage in those the division of pension plans and kind of those, I guess, more complex situations that get very, very contested. But still, it's, I think they have less maybe description in terms of what that license can cover.
Right. This is Joshua.
Yes, Joshua, and then Marcy next. Go ahead, Joshua.
One of the things that stands out to me like Rudolph, in paragraph B, there's the third line which says the approval of the supervising attorney. That's the scenario that I had raised before about supervising physicians in North Carolina and how we've expanded medical services through the process of having supervising physicians. So I want to make sure that maybe I'm not asking this the right way, but that's the issue I brought up before. Is why can't this be set up with a supervising attorney scenario in this state? And I thought the feedback that we had gotten from our friends and from others was that was not something that had been evaluated. But clearly here, that's exactly what they're doing in Minnesota. And even with that, they're limiting it to these very, what I'll say is more restrictive areas. Am I misunderstanding that, Brian?
No, Minnesota is, of the 3 active programs, Minnesota is the only one that requires a supervision of an attorney. I see Marcy, I think.
Marcy, so called on Marcy next. And yeah, Brian, if you can, and then I see, go ahead, Marcy. I see an iPad raised hand, but I'm not sure who that is.
That's Mac.
That's Mac. Sorry, now I can't see your face there. Okay, Marcy first, then Mac.
Okay. I think everybody's saying the same thing. I just want to be sure that family law is a very, very, very large area of practice. I mean, to just say you're going to have a paraprofessional that can do family law, I'm involved in some very complex cases involving business valuations. And so you can't just say, we're going to do a paraprofessional license to practice family law. So, I mean, there has to be a designation of the areas that you feel that this paraprofessional would be qualified, because they're not going to be a lawyer. They're not going to have the training, I guess. I don't know what training they have, but so, kind of like acquisitions and mergers. Obviously, you wouldn't have a paraprofessional doing that. You wouldn't have a paraprofessional having to deal with complex business valuations in a divorce situation where businesses are valued, and you have to do very specific qualified domestic relations order to divide retirements. I mean, everybody just keeps talking family law. I do think we need to figure out what areas within family law we're talking about. And as I've read the report, custody is by far is the one that they talk about all the time. Of course, I noticed Minnesota wouldn't allow a paraprofessional to appear for domestic violence. And that is the second area I think the report points out that we need help in the family law area. So I'm just saying that within the family law area, everybody talks about family law, but that is a huge area of practice. So we do need to start defining what we're talking about. That's all I wanted to say. And
I think that point's well taken. Let's do. Yes, go ahead, Cornudo Hodges.
So to the statement she just made, that's very accurate. We're saying family law without any specifics, but it would absolutely be restrictions on what areas within the scope of family law the paraprofessional or the limited licensed technician would do. Because like you said, we're not attorneys. So we're not going to have the same experiences that you have. And so we have tailored our interests in serving those unmet needs to our expertise, or the expertise that our research has determined most of us possess. So it wouldn't be a broad family law thing. Like you referred to, settlement disputes where businesses are involved, things like that. Certain mediations, if you don't have mediation training and experience, you can't do that in North Carolina anyway. So there are other components that have to be factored in when even considering what area the technician will be able to work in, because the statute already says you can't do this or you can't do that unless you have these other things. So we have considered those things. We're not asking to go beyond that. We do want to stay away from the supervision, because part of the problem with the attorney supervision, it still limits us as though we're still functioning as paralegals. And that's not what we're trying to do.
And briefly, Mark, I know Mac has his hand up, but I was just going to share this. I've been kind of looking for an opening to reference the legal needs assessment. Family legal services being identified as one of those areas that, of course, there's significant need. But particularly this assessment said that, among the surveyed issues in the category of family law, more than half of those respondents indicated a great need for services for domestic violence and partner abuse, followed closely by child custody, child visitation, and child support issues. It seems logical to me to kind of look at those as kind of maybe the starting point for this discussion. And again, seeing particularly with perspectives from Marcy and Steve, those that are just not just specialists in family law themselves, but this wealth of experience to kind of see what could come up in each one of those where it would be appropriate in terms of making this an effective thing to meet these legal needs. How much further, what sort of maybe spread should there be in that limited license to those particular topics, but where should it stop as well? And at which point really an attorney needs to be involved. So that might just be kind of a starting point as well.
Yeah, I think that's helpful. And I think we'll need to do that. I'm trying to decide how much time we dig into that now versus us later, or versus issues committee. Let me hear from Mac, and then I've got an idea maybe how to move things forward a bit. Yes, Mac.
Marcy and Steve, what do you think about the list that Brian just had up?
On the child support, I'd be okay if it was a guideline child support case. So in North Carolina, we have child support guidelines up to a certain amount of, I think it's 30,000 gross combined income a month. And so it's just a matter of, putting W-2s into evidence and that sort of thing. However, if it's above the guideline amount, and again, you've got income from businesses and, tax issues involved, I just don't think that, I think that would be a little complex. I'm not really sure that the public would be protected by having, somebody that's not as trained doing those. You see what I'm saying? So I think I'll be happy to, if you don't want to do this as a committee, maybe you should have, I think they had working groups in the last committee I had. You could have a working group of people that want to talk about family law, and maybe a working group that wants to talk about immigration or whatever other areas of landlord tenant, I think. But I do think I think the judges would be probably really happy to have help in custody cases. There's a lot of pro bono people going into court on custody right now. Is that your experience, Steve?
Absolutely. I agree with Marcy, really Marcy's initial assessment, which is child custody and domestic violence. Even child support cases that are guidelines, as Marcy knows, if you're self-employed, it gets tricky as can be. And so, you'd really want to give some thought as to exactly what kind of cases make sense. But we have pro se litigants in court all the time in custody cases every month, just lined up. And there are some efforts here to try to help, but there's not really a mechanism in terms of licensing to get people the help they need without getting lawyers involved. So I just see custody as crucial. And of course, the studies bear that out. But right. Yeah. Also, I'm curious to throw one back at Mac as to why immigration is totally hands off, because so much of that is form centric, and you have frequently translators helping people with those forms, and it gets really tricky, as those of us who have served on the Authorized Practice Committee know. We always have people coming before us that are trying to help people with forms and then run afoul of the authorized practice law.
This may sound awfully jaded, but I think there are some folks in the bar and in the political leadership of our state who probably wouldn't be all that excited about helping immigrants legalize their status. There seems to be a push to send them home. I'm not sure we want to step on that trap.
Barbara, I see you with your hand, and then Colin.
Yes, I hate to go back and talk about process, but you mentioned it at the beginning, you know, when we constituted this subcommittee, it was very clear that I think that its purpose was just to study. I mean, that was repeated over and over again. So I don't know, and maybe Brian or Alice could speak to this, whether we just have to kind of, at our next meeting, the issues committee, either reconstitute it or something to say, now we're ready to, you know, we've got these proposals that we want to do further study for, you know, and like Marcy said, maybe you keep, this is a great group. Maybe you keep this as an umbrella group, and you do have separate working committees that study, whether it's three, I guess this would be one proposal, the limited license, and under it, you'd have separate subject areas or something. Anyway, I think it is way too much for a group this size to get down into the weeds. And I do think maybe we have to go back to issues committee and kind of expand what this committee's doing. That's all.
Sure. I don't know. Alice, anything you want to comment on there?
Well, I think that was kind of the original concept, was that because there were all these proposals and new things happening all across the whole country. So we wanted sort of a way of taking that large amount of information and funneling it down and having a recommendation about, you know, what's something realistically that the state bar should pursue. And then to some extent, I mean, in the composition of the committee that might do that, I think it should include people who have specific experience. I also think it's really important that we make sure that we have a fair number of the counselors involved in that process, because one of the constituencies we have to convince of the merit of this proposal is the council itself as an initial matter. But yeah, I think the idea was always that this group, your committee, would be coming out with sort of the broad structure, eliminating those things that we think, well, they haven't proven to make any difference, or they're, you know, too difficult for us to accomplish here at this time, and get to the core of the stuff that we can really do and do well. But to start at this stage to try to really get into the detail, I think maybe it's premature. But I do think, in terms of going back to issues with, you know, what is it we or you all really recommend, I think that working through some of these things, you know, it should be subject matter specific. So someone should be able to get this limited license to do certain things in family law without specifying what those things are. But we know family law is an area where people are going unrepresented, where there's great need. You know, and I think the landlord tenant is another area where we know there's great need. And we also know in both those areas, there are things that are sort of small enough and not so complicated that having a paraprofessional do them just makes sense. And I use the medical analogy in my mind. I mean, you know, there are experts in medicine that all they do is like draw blood, but that's what they're certified to do. And so I think we could do that, but I wouldn't try to get really down to real specifics. I think that will happen in your next stage, which hopefully will include many of you all in that process as well.
Marcy, I saw your hand.
I agree with Alice. I think as far as getting the counselors involved, I mean, we got a lot of really good lawyers in the area of family law that are not members of this council that are good family lawyers. They should definitely be consulted about this. Landlord tenant, you've got real property lawyers that I think should definitely be involved and consulted. But I mean, I think if we feed off of the report, the equal access, or whatever it's called, that report, that seems to be makes sense to me. You know, so the study was done, this report has been generated, a lot of work was put into that. They have identified the areas where there's the most need. So why not just sort of, in the next step, just kind of take that and go with that and try to have some committees that have experience in those areas and come back with, I don't know, kind of makes sense to me.
I agree. I mean, let's do this. I mean, I think it makes sense for us to make a recommendation on limited licensure and then on areas that we think whatever subsequent group should analyze without trying to give the level of detail about this kind of hearing, not that kind of hearing, right? I do think that nitty gritty is beyond, what we could do. But I think it will help them in forming the right groups and committees if they know the practice areas that we're suggesting. And I think, we've done enough study and review that I think we're in a good position to do that. Let me do this just so we can kind of make it concrete as progress as we can. Let's go through some of those areas and just, I think we can use our voting, right, Brian? We've got the ability to do that.
Yes.
Why don't we, let's start with family law. And again, what I'd like you to do is, what we're voting on is recommending that the bar consider allowing some type of limited license professional in some portion of family law. And we know there's going to be things they can and can't do. That's going to be decided at a later date. But from a study committee perspective, do we think limited licensure practice in family law is a good or bad idea? And let's vote on that, and then we'll go through the other practice areas. I think that'll get us a quick sense of where we feel as a committee are the areas that we want limited licensure to practice in. So again, we haven't done a lot of voting. If you open your participants tag, if you haven't done that already, go ahead.
I'm sorry to interrupt you, but can we quit saying family law? Can we say custody, child custody? Or again, I mean, I feel like you're going to turn off a lot of people when they start hearing, paraprofessionals and they can do anything in family law. I mean, are we not, if we use the report, they were talking about custody and domestic violence. So are you saying that we go back with a report that just continues to use family law broadly?
That's my thought. I see Colin's hand, but my thought is the definition of what within family law they should do, I'm proposing be decided by what I'll call an implementation committee, as opposed to us trying to carve out. If we just say custody, I think we may have unduly narrowed it, or custody and visitation. But go ahead, Colin.
Yeah, I think, Marcy, I think Mark's prior comments are really on point. When we say family law, I think it's up to sort of a second generation of this process to narrow this. Just like when we say housing, we're probably not anticipating having non-lawyers close real estate loans and people buy housing, but we may be thinking that when it gets tailored, it may deal with eviction, summary ejectment, eviction, some of those things. And I think if we use the broad term of family law, I don't think any of us envision people doing dividing qualified plans and that sort of thing. But I think these are some areas that we ought to look at having paraprofessionals enabled to do some things that relieve the burden on people that cannot currently afford to have any kind of advice or help, and take some burden off the courts. I think your concern at this stage may be a little bit more than is needed, because I'm just calling it family law. I don't think any of us will envision, and I don't think that will get any traction. But I think when we talk about, we may talk about limited civil jurisdiction and say, that like some of the things in Canada, where up to a certain dollar amount, you can get some advice from someone, dealing small claims. But we're not envision people trying automobile accident cases with that. But I think we just need to push that down the road to the next generation of deciding how to limit this.
And thanks, Jeff, for your thought in the chat, maybe about giving examples so that we let people know what we're thinking about. That may be a good option. Mac, I see your hand still up. I didn't know if that's from before or new. Before, okay. Other people's thoughts on this? Again, I think the idea of giving a practice area guidance like family laws so that we can then get experts in that area to know, okay, now let's talk about what the right scope of services is. Alice, I see your hand.
Well, I think the report also needs to reiterate what the committee has learned, is that there are specific areas where the needs are great, and that ought to guide whatever the next generation recommends. And we can give examples there, from the family law arena or the landlord tenant, whatever, so that it's clear that we're not recommending that it just be a paralegal in family law with no limitations, but that we recommend that it be tailored to meet the known needs of people who are going unrepresented. And that we be very clear about that in the written report that we give to issues.
That was my concern. Thank you, Alice. You said it better than I did.
And I think that's well said. No, I agree. And maybe what really we should be doing is referencing, we can find as a committee that there's a significant need, for some family law services, and we can cite the language that we just saw on our screen out of the assessment, and then recommend that as a result, the bar evaluate using limited license professionals to fill that need. That's what I'm envisioning, and I think that's well said. So just because I envision there may be some different thoughts on the different subject areas, I thought it might make sense to raise them each in sequence, although family will have the most discussion. But let me put it to a vote to this group. Would you support a recommendation that cites the finding from the Access to Justice Committee around the areas of need in family services, and a recommendation that the bar explore having evaluating whether paraprofessionals can be licensed to address those needs? That's what I'd have in mind. Oh. Okay. Oh, great. My pollster's already worked on a nice generic question that I can use over and over again. That's
Yeah.
Brilliant. Okay. Terrific. It looks like that's a unanimous yes. Thanks for the quick work on the polling. All right. Well, I love consensus. That's fantastic. I think it may be shorter, but landlord tenant, I think, is another one that was front and center in the report. Let me ask the committee to vote on that. Do we want to make a recommendation that the bar evaluate limited licenses to address needs in the area of landlord tenant work? And again, we would cite the findings from the Equal Access to Justice Commission. That also looks like a unanimous vote. Terrific. I think maybe it would be useful, Brian, actually, but I think immigration and education are two others we've talked about, but do you want to, let's go ahead and we talked about education, so maybe that's a logical one. And thank you. You've gone exactly where I was thinking, is maybe pull up the other needs.
Yeah, and that's where, I'll just kind of say we have the landlord tenant issue, but I think one of the other issues that was raised by the legal needs assessment was the housing issue for owners, foreclosure situations, mortgage issues, home repair. So I think that might be worth a quick survey and vote by the subcommittee to see if that should also be included, again, referencing the legal needs assessments description.
That's a great idea, and I agree with you, Brian. And I think Alice's point about let's track these findings when we make our recommendation is the right way to present it, because it makes it clear this is what we're trying to address. So we voted on the second and third on the list. Let me go ahead and do that first one, housing issues for owners. And if you could run a poll on that, should that be an area? All right, we have a no and 11 yeses, so it looks like most of us think that that's would be an appropriate area to look at.
Mark, this is Steve. If I could opine on my no opinion.
Please, go ahead, Steve.
I believe that people facing foreclosure should have representation, but that's another one where you're talking about very broad categories of possible issues that homeowners would confront, and many very complex issues concerning property, title, and well, you know. So I just that's another one that would have to be narrow and qualified, I think, in the same way that we discussed concerning family law.
No, and that I think your point's well taken, and I think many of these we're going to have to define what fits in that scope, right? And even landlord tenant can be, a lot of it is straightforward eviction stuff, but it can be broader. So I think you're right, but I guess my thought is that's the next group needs to really think about, what it is, what is the scope, both substantively and procedurally, of what they should be allowed to do. So I do think that's important, but it's too difficult for us to hammer that out at that level. So, but no, thanks. Let's go ahead and I think let's go ahead down the list. It looks like immigration and naturalization was the next area. Let's do this, run our poll again, just to get a sense of whether this is an area that we think they should do. Open the poll, swinging wildly back and forth. The noes have it. The yeses are coming back. So clearly a little more divided as we go into that group. And obviously we had some discussion from Mac on some concerns in that area, and comments from Steve. So it does look like the yeses have that. Because it's so close, we didn't have a lot of debate. Let me see, do people want to chime in on why that should or should not be an area that paralegals can help in? And I know I already heard from you, Mac, but anybody else want to raise it? And I can't, let's see, raise your hand if you want to add anything on the immigration point. Again, because we're our study committee. I'm open to discussion. Anybody have any thoughts on that since it's divided?
I have a question for all the lawyers.
Yes, go ahead, Alicia.
Is there an intersection between federal law and state law when it comes to immigration? Is there anything on the federal law side that would affect the ability for North Carolina to pass something related to immigration? I know that immigration, I know at the federal level, there are already some they allow non-lawyer representation, but there are specific requirements for it. So I'm just wondering how that would interrelate with each other.
Anybody know the answer? I do not. We have some immigration lawyers in our firm that could probably answer that. I think it's a great question around, right? And obviously we can't let them do stuff that the federal immigration courts wouldn't let them do, or vice versa. I think all we would be doing, it's interesting too, in some of the authorized practice stuff, because it's federal law, not state law, there's some different treatment there. Again, my vision, and if we decide to send that recommendation, is get some immigration lawyers together, let them think about, are there needs and clients that they can't serve because they're not economically viable, or other issues where they think it would be great to have, licensed paralegals doing some of that work, and come up with a scope where they can help shoulder this burden and address the need. That's what I'm envisioning. But I don't know the answer to your question. I don't think, although we got a great diversity in this group, I don't think we have any immigration lawyers on our committee. So it's a good question. Again, I think highlights the need to form some specialized working groups that have that subject matter expertise to figure out what the right lines are, and draw those in a way that is big enough to satisfy the need without going so far that it's all encompassing and they end up doing stuff they shouldn't be doing.
Mark, just the quick thought, I think, Alicia, it's a great question. And I do think that it's really, as far as being able to practice in the immigration courts, that's going to be more of a federal issue. What I think we would, or how it kind of intersects with what the bar is doing with regards to regulating the profession, is really the authorized practice issues that Mark had just mentioned. And particularly the thought that somebody is offering legal services in North Carolina. And so therefore it's kind of under the jurisdiction of the North Carolina State Bar, particularly the instruction by the General Assembly for the State Bar to enjoin those sorts of unauthorized activities, and that sort of offer of legal services, even in that federal realm, I think is still a North Carolina issue, as much as it might be an immigration court issue. But frankly, I don't know that they really have the mechanism to go after those engaged in unauthorized practice of immigration law. So nevertheless, I agree. It's a great question and something that I think was certainly worth exploring.
And the only thing that I was going to add also was that the list that's here is not complete, but I do know that within the survey, when folks were surveyed about this issue, it wasn't really talking squarely just about the immigration court hearings, but for folks who have different kinds of status that are trying to access benefits, or, it does mention driver's license issues. So I think that there's a lot of potential civil issues that intersect with immigration status.
Terrific. Thanks, Mary. Any other immigration thoughts? I mean, again, I'm inclined to go with, it was 8-5, I think, so we'll go with the majority in terms of a recommendation that it be looked at. Just a reminder, we're not voting on a formal policy change. We're voting on what recommendation we want to make for further development to the Issues Committee. Brian, maybe if you go back to the list, it's worth discussing and or voting on the remaining items. Again, some, I think we just probably, I'm inclined to perhaps just go through each of them. Some are pretty broad. I mean, obviously seniors, there's a variety of issues facing seniors. So I think you'd have to do a lot of carving out there, but some of the specific stuff around Medicare, Medicaid, there's clear demand. I don't, they've got issues with power of attorneys and living wills. I don't know, we'd have to think carefully about whether this is a broad, authorization in terms of trust and estates work, or how we want to handle that. But I think it's probably worth discussing. Again, my thought might be to get some elder lawyers experience in that area to do a similar analysis on assessment of whether there's areas that limited licensed professionals can add, particularly again for low income people on Medicare, Medicaid that may need help. So, but let's go ahead and just do straw polls. We'll finish the list and then pick that discussion back up. So Brian, let's do seniors. All right, looks like 8-3. Let's do healthcare. All right, let's do income maintenance.
And just so we announce it for our record, that was a 9-2 vote yes on healthcare.
Thanks, Brian, for the reminder. Yes, for people that don't see the polls. And it looks like if we close it now, it's 9-3 in favor of income maintenance. Let's move on to consumer rights.
Looks like that is at 8-4 yes.
8-4 yes. Okay. And let's move on to employment legal services. Let me say, let's take the votes, but if anybody wants to discuss it, I don't want to get a sense of us ramrodding stuff through. So we can certainly talk further about any of these even after the vote if you want. I view it almost like a straw poll question here.
All right, so employment is, I think we're thinking a lot about this one. This is the closest vote yet. It's yes, 6-5 in favor.
All right.
Oh, 7-5 is the final vote.
7-5 is the final vote. Nail biter here. We got the driving the Vegas people crazy trying to figure out how these votes are going to come down. All right. Let's do civil rights and discrimination. It's bouncing back and forth.
Well, we have a split,
All right.
6-6. So I guess that one will require further discussion, or perhaps that's just, I'm not sure if that we deem that to be a failed recommendation, Mark.
Yeah. Let's come back to that at the end.
Yep.
and see if we can have anybody persuaded. My inclination though would be to not recommend it if we're that divided. You know, we have enough other stuff, but I think it's a good question. And let's do veteran military benefits, then we'll come back and talk about the civil rights.
I think that'll end at 9-3 in favor.
Okay. I mean, I think to me, the good news is we got a number of them where we have a strong, not a consensus, but a strong majority that think these are areas that can be addressed through paraprofessionals. Again, the one that did not get a majority vote is civil rights discrimination. Anybody want to address that, either why they voted yes or no, or whether we want to include that in the list? Steve? You're muted, Steve.
Let me talk about an area I know a little more about than civil rights, and that's consumer rights. There are a lot of laws, both state and federal, around consumer rights and the protection of consumers. And I think with all of these categories, there probably are limited areas in every one of those areas that might make sense. But I voted no to some and yes to others, again, with that caveat that there would need to be some drill down and exploration as to where the limits are on what a non-educated, lawyer-educated advocate could do to help people without screwing up their case worse than, you know, without costing them a good claim. And I think about the consumer rights area, and I suppose civil rights is the same, very complex area of law. State and federal laws that broadly address discrimination, employment. You don't want to be messing around in there. I mean, I don't want to be messing around in there. And I've been to law school, but there may be limited areas in each category that make sense.
Thanks, Steve. Other comments, thoughts? I mean, I do think that's a theme on a lot of these is some of these are broad areas, consumer rights, senior care. I think the hope would be, you know, to find areas. And I just remind everybody that, you know, while many of us may view, you know, lawyer representation as a gold standard, what the needs assessment finds is there are lots and lots of people getting no legal advice at all. And so the question is not really between a skilled lawyer and not, you know, and a paralegal. The choice is often going to be between nobody and a limited license paralegal. And, you know, and so I think we've heard that I think a lot of those folks may be better off with a limited license paralegal. Your points about protecting the public are key. And obviously we're going to have education protocols and other stuff built around licensure to make sure people are competent in the areas they are practicing. And that's going to be important. That goes with the license, is that duty of competence. And I do think it's a struggle. And I think, you know, the civil rights area is certainly one that's broad enough that you know, it's putting the parameters or definition around that is harder than in many of the others, which I imagine is why we're as divided as we are. Mac.
And one of the reasons that I started voting no down near the end of the list is if we go in with 10 areas, then we've got 10 chunks of the bar opposed to it. And several of them have politics baked in them, and we risk losing the whole thing. I think we need to, I very much want to see this program go forward. And I think we need to do it in a way that gives it the best chance to win.
Yeah, no, I think that's a good point. And, you know, I do think, and we may get feedback, you know, from if we form a subgroup on whatever, immigration or elder law, other stuff, their recommendation may be there's really not a good area, not a good fit for paraprofessionals. So it may be that some of these areas drop off. I'm trying to balance, and again, we're just making a recommendation at this point, but part of me says, well, we want it to win, you know, if we're going to make this push, I'm okay with incrementalism, but do we want to come and keep adding new practice areas? That's the balance, right? Do you do it and establish protocol with enough critical mass that it moves forward? I think that's difficult. Joshua, I see your hand up.
Yes, sir, and it's probably sequentially out of whack. I think in line with Mac's comments, I almost wished I would have said it before the voting started, but unless it passes by a supermajority, it shouldn't even go on the list of recommendation to move forward. Because I believe strongly with what Mac's saying, that if we walk in with 9 or 10 areas, it's going to be very difficult to get support, and people are just going to turn it off when it goes.
Gotcha. Thanks, Joshua. Other comments? I see Marcy. I see your hand. I think you're muted, Marcy.
Sorry.
There you go.
What are the top 3 needs? What were they? I know family law, landlord, tenant. What was the next? I mean, if we're trying.
I think it was housing issues. I guess I'll kind of broadly describe as both owner issues and landlord tenant renter issues. Family law, and then immigration, I believe, was the next one.
I mean, I kind of agree that we should, if we want to not scare everybody off and give them a bad taste in their mouth at the beginning, that's what I'm worried about, I guess. That was one of my worries with just saying family law without any qualification, is that all the family, there are a lot of family lawyers in the state, and I know they're all going to be up in arms, and I know that my phone is going to be burning up.
Well, to aid in our discussion, I think one of the other figures, and this is something that Alicia had mentioned to me in the chat, just that this might be a helpful chart, and I think she's right. These are here in the legal needs assessment. These are the top 10 types of cases that you see are from the legal needs assessment, and you can see that if you start looking at these different types of cases, this might be a guidepost that we can use as far as drilling down into those specifics, but you see kind of a couple, or just like really a small handful that really jump out at you when you talk about summary ejectment, foreclosure, things of that nature, findings and order of foreclosure. Those are housing issues. And then you look at divorce, domestic violence, custody, civil no contact orders. Those are going to be family. Of course, incompetency and guardianship issues are kind of both family issues, but then when you talk about guardianship, I guess it's kind of depends on what type of guardianship you're talking about. But ultimately, I think there's this can be also a guidepost for the subcommittee's recommendation in looking at these are the types of cases that are incredibly prevalent. They're going on all the time, and this is where, if we're talking about meeting the needs that have gone unmet to this point, these are the types of cases where folks are showing up without any sort of representation. And again, it's kind of distilling everything in this assessment into some sort of structure, or just really a foundation upon which any sort of recommendation can be based.
Thanks, Brian. And Marcy, to your point, I do think I envision, just like clearly in family law, we're going to need family law practitioners meeting either with our committee or new committee and hammering out, okay, what are the right areas? And I think by doing that, hopefully getting the buy-in from these different practice groups, so that the family law folks say, this will help. These are folks we can't serve. This is a real need. It's unmet by our current folks. We think, limited license professionals can make a difference. And similarly, I see that happening in the housing areas and in immigration and in elder law care and other stuff. And again, those teams may get together and say there's not a big area that we could productively do it, but I'm hoping to use the process as a way to build support for limited license work. Go ahead.
Well, Mark, in your report, which I guess will be made public, which then the lawyers will start seeing, I mean, can't we attach to that just some example? I mean, some of these charts,
Yes.
this report, so that they can see that we're not talking about, because when they say divorce, they're talking about just absolute divorce. We have a lot of people that go into court, no issues, just want to get their divorce, and they do that by themselves all the time. So that's what that means, I think, when it says divorce. I think that means absolute divorce without any other issues. But my point is, again, just this is the first they're going to see. It's the first report they're going to see coming out of this committee. And when they see the term, the limited license I can tell you it's going to, panic is going to set in. So if at the same time in the report, you can let these lawyers know we're not talking about every issue in family law, and maybe even attach some of these charts to the report, from the equal access report, then, you know what I'm saying? It kind of shows that these are some of the areas that this report has pointed out, and that's what we're looking at.
No, that makes sense. No, and I think I agree with you. And I think to Alice's point, we need to tie off of that the findings from the Equal Access Justice Report, because it does provide that guidance. And it'll take a little time to do a written report. And obviously, I want everyone's comments and thoughts on that too. Obviously, we need to figure out where we are before we report it out. So that's kind of the goal of this meeting. And I think we've made some progress in that regard. And I know we have other topics to talk about. I might suggest this. I guess, Brian, the other big issue that I thought, when we go back to your very first chart, looking at other programs, we need to decide if this is a temporary, is our recommendation of a temporary change or a permanent change. We haven't spent a lot of time talking about that issue. So I welcome, and I do think that's another one where that's a big structure issue that at least a recommendation from our folks may be helpful as whoever takes up this baton works on the logistics. So let me get thoughts on that. Is this something we just say, this is a new structure and here it is, or do we want to present it as some kind of 3-year trial program or something else? I welcome thoughts, because obviously other different states have taken different approaches on that.
I saw Mary had her hand up for a bit, and then Jeff.
Yes, sorry, I didn't see that. Mary, and then looks like Jeff does too. Mary, and then Jeff.
My only quick comment about the chart that Brian shared was just a reminder that is only issues that would find themselves into state court. So there's things like that were mentioned, like wills or like benefits work, that you won't see included there. So just good to look at various charts within there, because it kind of captures different pieces.
Thanks. Good reminder, Mary. Jeff.
Yeah, I was going to say, for the most part, as far as the scope or duration of this, I mean, a reasonable pilot program that gives long enough to actually let folks get some benefit of putting in the effort of getting credentialed seems to be the most popular way of approaching it. But I'd be curious to hear from everyone else on how long you'd think to actually see results from having some paraprofessional role.
Let me, Colonel Hodges or Alicia, do you guys have thoughts on that? You have thoughts on, should it be for a period, or should we just change it, or what? I'd welcome your input on that question.
When you say a period, what period?
Well, I think
he said 3 years, but I think that's an extended period. Something shorter than that, sure, because the goal is to get it started. If we can get it started, we can gauge it after that. Like you said, most of these conversations will go further once we get something in place. If we want to restrict it to a time frame, great. That's the only way we can see what the information or the data supports is working. So if we start with something small, let's say if we go with what he said for 3 years, I don't want to do 3 years, but if we did 3 years and we looked at it and we said, okay, this is what we have been able to accomplish in the last 3 years, we'll be successful moving forward in this area, this should be removed. I personally feel you can see that in a year, but that's the approach I would take if we had to give it a time frame.
Let's see, I see Camille and then Colin and then Warren. Go ahead.
So in thinking about the interest of the paralegals, it's not an exact comparison, but when the Bar Association started the paralegal division, it was after a long period of sort of lobbying the organization and, having discussions and getting buy-in and et cetera, et cetera. sort of hard to remember today when you look at how active and vibrant the division is, that it was a very hard fought battle. But I remember, people saying, well, we just don't think you're ever going to get 100 people who are going to want to be a member. So fine, we'll try it, but it's not going to happen. And we had hundreds of applications in a very short period of time. And, Alan came up later and he was like, all right, at least I'll say when I'm wrong. I was wrong. There was a lot of interest. And then when we started the state bar certification program, I think interest exceeded what we had initially thought it would be. I don't know if everybody on the call knows or not, but the paralegal certification program contributed $1 million to that new building, the state bar building. The paralegal certification program has been very popular in North Carolina. And so I believe you're going to have a lot of interest. And I believe you've got people who are watching this YouTube meeting today who are very interested in the outcome. And so I hope that we will not have a temporary period. I hope that we will develop a program that we can begin to implement, because I think it'll be good for the citizens of North Carolina. And I think our legal profession we will know how to handle the issues that come up. We will be able to develop a program that will work and that will serve the needs and that will protect the public at the same time.
Thanks, Camille. I saw Colin's hand and Warren.
Yeah,
and Marcy, I think. Yeah, go ahead.
I think this process will take a while because, even if we came up with some very specific proposals, and it probably will take a second generation of committees to do this, we're talking about changing the definition of practice of law, as I understand it, and that'll require some legislative changes. And then, given that and the uncertainty of that, you'll have to go through some sort of licensing or certification process. So, it's going to take a while. You can't just wave a wand and make this happen. So I think we need to think this is going to take, a couple of years probably to get done under good circumstances, and then we need some period to evaluate the changes that get made and whether or not they're successful at meeting the goals that we've been trying to meet. And if they have not, why, and can we change it to make it more effective, or if it has, can we expand it?
Thanks, Colin. Warren?
Brief history. I first met with paralegals trying to organize what we have today in 1999. So it took 6 years from that first meeting, and that may not have been the beginning. I'm also working with the folks in Oregon. I work for one of them who is on the committee in Oregon trying to build their program. And an issue that came up in a recent meeting was, we're now going to ask from the planning board at the bar or the court system, we're now going to ask the paralegal programs to recreate their program of study to cover the specific areas that we're going to license. So if you're looking at an experimental period of time, keep in mind that it takes about 18 months to change a course from a paralegal program request to the NCCCS back to implementation, 18 to 24 months. So if that education piece gets rolled in, you just added 2 years to whatever you were going to do along the way. Thanks.
That's helpful, Warren. Alicia, I see your hand.
So my thoughts are two-part, one with regard to the education and one with regard to people who might be interested in limited licensing. I feel like if you're going to have a pilot project, I feel like that is going to limit the people who might buy into the program. It's taking a risk because you're asking them to invest time, you're asking them to invest money, and they don't even know whether the investment, whether there's going to be a return on the investment. And I think it's the same issue on the education side. You're asking these community colleges to come up with these programs and change everything around, and they're not even sure if this is going to be a permanent thing for them. So I think you have to consider the other stakeholders who are, potentially buying into this licensing program.
Those are good comments. Well, I'll say, I mean, based on those comments, I'm not inclined to recommend a specific term limit or, end date, unless someone wants to argue that that's important and should be part of our recommendation. I think we recommend, this program, and we don't tie it to any specific time period. Because I tend to agree, if we're going to make a change, it's a huge change. We should just make it. Obviously, if it doesn't work out, either people won't participate or you could change it at the end. But I'm not hearing a good reason to necessarily try to have a fixed end date for it. If we're going to make the program, let's do it. So we won't have any specific recommendation on a duration limitation in our recommendation, it sounds like. Now,
but we're also
yes, Joshua.
But we're also not going to recommend that there not be one imposed. Correct. We're just going to stay silent on it.
Sounds like I don't know that we need to address any time. Yeah, I'm proposing to not address. I'm proposing we just recommend that they move forward with it without addressing duration explicitly, unless we think we want to. Well, let me ask, do we want to include anything about duration in our recommendation? Mac.
Mark, I think that going in with a recommendation for just a wholesale change is the way to get what we really want. And if it runs into really strong headwinds in the legislature or somewhere else, and that gets thrown up as a way to make it palatable, then that's a decision for somebody else to make several years down the road. But we ought to ask for what we want.
All right. Sounds good. I see a thumbs up from Jeff.
I
see
that
Steve, go ahead.
We should ask for what we want, but I'm not sure we know what we want. So I was listening carefully to Alicia, and I thought her points were good about why you wouldn't want to have a time frame. Of course, up to that point, I was firmly behind Jeff as to the reasons why we'd want to have a pilot, time period. But so I'm sort of not sure what we want to do, and maybe staying silent makes sense. And also we're talking about report in one conversation and recommendations in the next. And so what are we doing? Are we preparing a report that contains recommendations, I guess?
So good question. And Jeff, did you have a comment? I see your hand. Let me let Jeff go, and then I'll address your question, Steve, as to where I think we are in the process.
Yeah, I won't belabor the point on the duration. I'm not saying we should have one. Maybe I inartfully asked kind of if there was one to be imposed, is there a way to make sure? And I think that Alicia frankly made the point I was asking far better than I could have, which is people are going to be building programs around this. And for it to be successful, there needs to be some, assurance that what they're investing time and effort into is going to be around at the end of it. So I'm perfectly on board with, let's just ask for what we want, make sure that we're giving good reasoned recommendations. And if someone poses duration, we can debate what that runway looks like later.
All right. Thanks, Jeff. And I think I'm not sure Joshua agrees with that, but it sounds like it's a consensus of most of the other folks that's kind of where we go. And we want to propose the change. We're not going to propose this from the beginning as a pilot or a short-term period. We're going to propose it. To your question, Steve, about where we are, I think it's a two-part. I was hoping to do today, because I'm sensitive that these things all take time, and I'd like to get a report to the Issues Committee when they meet in person next month. And I think I've accomplished that in terms of some general guidance about our committee is recommending further, action around limited license professional in the areas that we voted on. And I think that's our recommendation. My hope is that they can then start the process of figuring out what that structure looks like, who are going to be the working groups or subcommittees or other things to begin, creating a proposal. That is different from I also committed at the very beginning, our committee will do a written report on recommendations. I still think we got a little ways to go before I think we are in a written report out from the committee. There are obviously other things like court navigators and the regulatory sandbox and stuff. And I guess my thought was the report would be kind of a conclusion of our work. And we certainly talk about limited licensure, but I think it's going to be more comprehensive. My goal in moving things on today and having a discussion and some votes is I don't want to wait. Let me be, certainly it'll probably be, my goal's been October. I still think that's attainable for a report, but I didn't really want to wait for October to then tell issues to get going. If we can save that time and make, let them get started on it after July, we gain 3 months. So, and this seemed to be a consensus of urgency. So that was my goal today, is give some direction so I can make a report at our July meeting saying, this is what we think. We think this is worth moving forward on. Go ahead and do what you need to do in terms of setting up committees. Limited licensure, something our study committee has concluded is an important area, and here's some guidance in the topics. And then we will meet again in a month to talk about court navigators, because I'm not sure we're going to get to it today. And I know Jeff has formed a small working group to look at some issues around regulatory sandbox, and I want to have a discussion and have a discussion and a report on that issue as well. So that's kind of what I envision in terms of a report, but I don't want to be delayed by, having a detailed written report if we can kind of give the issues committee a sense of where we are on this first issue, because it seemed like the priority. So that's my thinking there. Let me go back to Brian. I know a real issue is the practice of law. We were going to jump to that. I kind of took things out of order, Brian. I apologize, but I wanted to make sure where we were on moving forward before we spent a lot of time on what I view as some of the hurdles. But I do think it's worth us all being realistic about the fact this is going to require statutory change. And so even if the state bar were 100%, let's do this tomorrow, we can't. And so we are going to, and I love your volunteering, Ashley Campbell, to join the legislative push, because I think that's going to be important. And obviously we have a great legislative committee in the state bar and can decide what and how we want to do that. But there are issues there, and I know we've got some materials on that. I'm trying to decide, does it make sense for us to go there now, Brian? Do we want to do that? How do we want to spend our last less than half an hour?
Yeah, I don't know that we need to get into any sort of incredible detail. I think we all understand that statutory changes need to be made. And this isn't so much about changing the definition of the practice of law. It's going to more so be changing the statutory authorization for who can practice law. I spent some time looking over Chapter 84 over the past couple of weeks. Of course, we're always looking at Chapter 84, but looking at it with this particular thing in mind. And really, this is the primary statute that needs to be amended. This is the one that makes it unlawful for anyone who is essentially not an active member of the North Carolina State Bar and admitted and licensed to practice as attorneys at law. To appear as an attorney or otherwise engage in the practice of law. We would need to amend this one. All the other statutes, there are different kind of administrative amendments that I think will need to take place. There's updated language. There are things like, there's I guess the very first section, 84-1, deals with the oath that attorneys are to take in practicing law. There's fraudulent practice considerations, essentially establishing a claim of a right of action for somebody who is defrauded by an attorney. And I think we'd have to look into whether or not this person that's a holder of a limited license should similarly be kind of on the hook if they defraud somebody. I feel like the answer is probably going to be yes. We're going to treat those with the limited license the same way that we treat attorneys. DHC counsel involvement, and then I guess that's the question being, should there be some sort of allotment of counselors that are to be selected from those with a limited license. So there's some buy-in to the overall governance and regulation of the profession, which they are now a part of. The thing that I guess if there's one statutory concern that I have, and this is something where we can get into the working group, I think, but I feel like I just want to kind of present it briefly here so you can think about it, is the question of who does the licensing. Because right now we have a bit of a unique setup. In North Carolina, you all know that the Board of Law Examiners licenses attorneys. They then turn those licenses, those files, over to the State Bar for regulation. that structure really kind of exempts us from the Occupational Licensing Board statute. And with the Occupational Licensing Board statute, if we, the bar, were to become the entity that licenses these individuals, we would presumably fall under that particular statute, and we would have a number of different requirements. There's some, we have some really specific administrative processes here with our disciplinary program, or just the general regulation of the profession through the state bar's authority. But we would have to kind of bring in, I guess, and maybe just answer these questions about, well, does the Administrative Procedure Act come into play here with regards to just this part of our activity? Or does the Board of Law Examiners now take under their umbrella the licensure of these folks that have the limited license? So I think those are questions that, you know, it's not really worth our time to get into now. I think that requires some specific study, but it does add to the, I guess, just the complexity of the situation in making this thing happen. I think to Colin's point earlier, you know, there's a lot of statutory amendments that would need to be made. A lot of just kind of just figuring out exactly what those proposed amendments would be is probably going to take some time. But nevertheless, I guess the way that I look at, particularly with regards to the authorized practice issues, that one is frankly, I guess it's a big statutory change, but it doesn't require as much statutory amendment, because we're really just expanding those who can practice law, and the definition of the practice of law can stay the same. Whether or not we want to change the definition of the practice of law for other reasons is a totally different topic that we will not get into today.
Thank you, Brian. No, that's a good reminder. And obviously there are a lot of moving parts. So one good thing about being a study committee is we can say, this is a good idea, this is what we want, getting there is hard, and we'll kick that ball to to someone else to look at the legislative change, the licensure piece, examination. Obviously there's a lot that has to happen, but I think we can start that off by saying we think there are unmet needs, and we can get limited license professionals helping meet them. And that's something we want to see happen.
Mark, I'll just kind of quickly add we were going to talk about court navigators potentially and document preparers. Those different things like document preparers, that might be something that would also require some sort of statutory amendment, because that is something where we're talking about the practice of law and how specific actions as attorneys. I don't know if everybody can hear my children yelling in the background. I apologize for that. But there are specific efforts that attorneys can make that would, I think, fall under that idea of what a document preparer would do. But something like court navigators really would be a program that ideally, at least if we follow the model that we have in New York City, those folks are not engaged in the practice of law. They're not really running into any sort of statutory situations. It really becomes a question of, I think, funding, but maybe even more importantly, just kind of a buy-in from the court system, that the courts would essentially bring in, whether they are volunteers or and of course funding for the volunteers, or employees of the court system that exist to help pro se litigants as they get into the courthouse, just to have a resource to go to and say, where am I going? When am I allowed to speak? In the New York example, they have their court navigators that can actually answer factual questions posed by the judge or the opposing attorney on behalf of one of those individuals, but not answer any sort of legal questions or give legal advice. But I guess my point in describing that here is that that's not as much, that particular idea, court navigators, is not as much of a statutory thing as much as I think we would make a recommendation to the court system to try to pursue something of that nature. So that might be something to think about in anticipation of our next meeting. Just again, as we start mulling over these ideas, keep that in the back of your mind.
No, I think that's helpful. Let me ask the group this. I mean, we did hear about court navigators. I think it is, a smaller step. The document preparation is interesting. We looked at Minnesota's model. They had a list of documents that those limited license professionals could prepare. And that might tie in, well, if we decide to use that model of having, here's a list of things that, if you're a licensed paralegal, you can do. So I guess my question is, do we want to, I know we 2-hour meetings are long. We do still have a little time. Do we want to tackle those? Do we feel comfortable talking about court navigators and document preparation? Do we want to, Colin says, yeah, I see some thumbs up, some rigorous souls ready to keep moving. Let's do it. If we can't finish, we can't finish. But let's talk about it, because again, the number of people voting in favor of court navigators was pretty high. Anybody want to speak to that or opposed to it? Is this something? And again, this is probably just a recommendation to the state bar that turns into a recommendation to the courts, because again, it's not something we would directly implement. Marcy.
Do we have the list of, I'm sorry, I don't know off the top of my head what the list for the Minnesota.
Oh, for the documents, what documents they can prepare?
We're even talking about. Yes.
Brian may be able to pull that up. It's referenced in a previous subsection to the one you had on the screen. Let's do this. Let's talk about court navigators quickly, and then maybe we'll move to documents because that may be more involved. Anybody have thoughts on court? Do we want to make a recommendation about court navigators?
Hasn't the AOC launched an aggressive sort of court navigator program already?
Well, not so much a court navigator, but they have they've launched their self-help, kind of their forms that have been revamped. I don't know if they're actually putting, I feel like I remember hearing about kiosks that would be in courthouses and things of that nature. I don't know if those have actually been installed or if they're even being pursued. But I feel like that's been their effort of kind of increasing the self-help aspect by providing those forms and kind of fillable forms, things that take you through just to get some sort of document. But I think that's the limit.
But you can sit at your desk at home with the system they've got on the web now, and you don't have to go to a kiosk at the courthouse. What's the difference other than convenience?
Well, I think the big difference, the court navigators, like the New York program, which has been successful, they expanded it and we're happy with it, is actually live humans in the courthouse that will take unrepresented parties and say, this is where your hearing is, this is what's going to happen, and kind of guide them through the system. Sometimes introduce the party, limited role in front of the court. But, again, they're not providing legal advice, but they are basically being courthouse guides. And it's been pretty effective in, helping pro se people navigate the process. To me, the funding issue is a definite concern, because the question is who's going to pay for these folks. They're not really practicing law, so I don't know that it is directly going to be necessarily a regulatory issue. In other words, I'm not sure there's a change to the rules of professional conduct required to have court navigators. It's more the courts embracing it and then someone finding out a way to fund, this program. But the idea is you'd have someone there that would actually go and sit there and sit through some of these court proceedings.
Okay, thanks for clarifying that. You're talking about a person.
Yeah, it's a person. It's not a technology solution. It's a person.
But raising the budgetary question again, we've got to find some money for all of this stuff.
Mark, this is Ashley. May I make a comment?
Please, go ahead.
So I'd just like to just speak in support of court navigators. I think those of us who I've practiced in district and superior court throughout North Carolina, but in district court particularly, and in different venues like domestic violence court, for example, a court navigator could really make court more efficient, and I think serve the public in a really important way. And then I just want to, there's already a program in in Mecklenburg County, a self-serve center. Now that's a little bit different, but it's a place where people can go to ask questions and really have a better understanding of what's going to be happening, where do they need to go, where do they go to file things, et cetera. And I think that can only improve the experience with the justice system. So I would just support us making a recommendation to do that, of course, with the understanding that the funding issues and things like that would need to be worked out.
Thanks, Ashley. Any other comments on Court Navigator? If not, I propose we maybe vote on supporting a recommendation around Court Navigator. I think it's very different because it's not going to be something implemented by us as a state bar. It'll be a recommendation kind of flowing out of the needs assessment. Colin, did you want to say something?
I mean, I think the role of court navigators has been thrust on our judges, and I think it takes time. It makes our courts less effective. It puts the judges in a very difficult role of trying to answer questions for individual litigants on one side. I think it will be, if there's some study of it, I think it will be a much more economical use of time. I mean, particularly in a place like Wake or Mecklenburg, where you have, we run 20 district courts every day. Having someone there will, I think, save tremendous amount of judicial time and make our things run more efficient.
Thanks. Alicia, I see your hand.
I do have a quick comment. I think I'm in favor, obviously, of the Court Navigator program, and I'm going to maybe talk just very briefly about the benefit that I can see. So when I look at the New York model, I know that they contemplated not just directing them towards paperwork and making sure that they're in the right place, but they were also considering kind of the emotional support. They actually wrote it in their manual. And so one of the ways I can see the benefit of that is I've been at hearings, at 50B hearings, where there's domestic violence and someone, they don't have access to an attorney, they're representing themselves, that it's a civil case. And I've seen people who've been allegedly victims of domestic violence have to go up there and sit at that table by themselves and face the person who, allegedly beat on them by themselves. And it can be a pretty, traumatic circumstance. So just being able to have a court navigator to walk you through what needs to be done, give you some of that kind of emotional support, be able to sit at the table with you when you're falling apart, trying to put your paperwork together if you have evidence, things like that, I think would be tremendously helpful. And, those kind of situations, but also in family court situations.
Thanks, Alicia. I appreciate it. And thanks, Mary, for putting that link in if you wanted to review that. Any other comments on Court Navigator before we vote on whether to include a recommendation that this be something that the bar consider? Again, probably a recommendation that they consider recommending implementation of a Court Navigator program. If I don't see any others, Brian, Mr. Pollman, can you put up a poll, or do you want me to just phrase it and have us vote? Yes, there you go.
The title is incorrect. Ignore the permanent or pilot thing. We did that without a poll, and I forgot to change that.
All right. Wow. Sounds like unanimous on Court Navigator program. Terrific. I'm glad we didn't wait till another whole meeting to do that. Let's see if we can make similar progress on the document preparation piece, which may be more complicated. Brian, you're ahead of me again, Sharon, these are, okay, let's take a look, because I've not studied these either.
Yeah.
This is from Minnesota. This is the list in Minnesota.
That's correct. This is the in Minnesota's program, they had an appendix listed where these specific things can be prepared by folks that hold the limited license. So you have these very specific things. I have to say, what I was trying to find was the list that also exists for Arizona. Arizona has a similar sort of list, and I could not find it very quickly as far as what sort of documents, because they have the actual certified document preparer program that's been in existence for some time now. And now that I'm talking, I think it may actually be in one of their statutes that exempts preparation of those documents by a certified person from the practice of law. But nevertheless, I'll try to find that and get that to the committee. But generally speaking, this is at least in Minnesota, and I think it really kind of hits on a number of the different documents that can show up in probably the most commonly needed legal areas.
Brian, I guess my initial thought is, wouldn't be, if we're forming a group to look at landlord, homeowner issue, renter issues and family law issues, that maybe those groups could also consider what types of documents those limited license paralegals would file. And so I guess there's two pieces. One is, what is the scope of what a limited license individual can do? The second is, do we want to create a new category of documents that you don't need to be a lawyer to prepare, right? Am I right? Those are the two issues.
I think you're right, Mark, and that's just the issue that I think it was Dave Byers from Arizona was highlighting, saying that they've had this certified document preparer program for some time. And now they have the limited license that really has kind of incorporated a lot of that. That it's not that they got rid of the program, but in some ways there's a bit of redundancy, or maybe just a pathway that somebody can choose. I only want to do the certified document preparer thing, or I want to actually go after the limited license. Perhaps, there's additional educational components, because the certification for their document preparer program was less stringent. I think it wasn't as significant as the limited license. But seeing that we don't have that as something that already exists, I think it makes sense to kind of incorporate this the way that Minnesota is, to say that the holders of this limited license can take certain actions, what sort of representative capacity. And again, those are details that we'd get into in working groups, but also what documents should be permitted for preparation.
Thanks, Brian. Anybody have comments on or thoughts about the document preparation piece? Jeff, I see your hand. And then Alicia, I think your hand, I don't know if that's new or before, but go ahead, Jeff.
Yeah, so the one thing I'd suggest, I'm supportive of this. I just want to think about how this impacts our existing online document preparer rules, and whether that could be read to, in some way impact what I think people are already approved to do. For example, looking at the specific list, there are a number of documents that I'm seeing that I'm aware of online document preparers that we've already approved can offer these services through a website. So that it's a human being doing it in person, I don't know that. It could just be an expansion of the existing rule, what we already have going on.
It's a great point.
That is a good point. Let me ask maybe Ashley, do you have a sense, or Mary, are there some documents separate and apart from the licensed paralegal approach? Are there documents that if people were able to prepare without an attorney, we could address some of those needs? Has there been any discussion around any kind of exception for document preparation if we're staying focused on the legal needs?
I'm not sure if Mary wants to address it or not. I know, the Equal Access to Justice Commission has worked on Guide and File. That's Jennifer Simmons, who was so involved in preparing the divorce pro se packet. And so they've looked a lot at what types of forms can, potentially be prepared on a pro se basis. I know that doesn't answer your question specifically, but there are certain people in family law, for example, right now, who you can pay to see who can prepare documents for you to file pro se. So that already happens in the private market. And I don't think it would be a big leap to do this with document preparers.
Yeah, I think that's right. And I think with Guide and File, there's only, I think it's 10 interviews now, but I know that they've got a list of what they want to come out next, that they're working towards, and now they have more staff that are supporting that process as well. But I think some of the things really staying on the list that Brian keeps sharing, like I think is it something that these subgroups could do is really parse through that too. Like, well, maybe this is something that a licensed paraprofessional could do. Maybe this is also something a document preparer could do. I don't know.
Marcy?
Sorry, having a hard time with my mute button. And the other thing too is in our family law world, we call things different. Some of these documents, I don't even know what they're talking about. So I think that the documents would be state specific, at least in the family law context, because we don't have some of these documents. I don't know what they even are, but we certainly know what documents would need to be filed in North Carolina in the family law court system. So I think they need to be studied together. And of course, in our existing laws, we're not trying to change anything that's already existing law. This is just adding to it or expanding it, I guess.
Why don't we do this? I think, again, from a study perspective, it does seem like it ties in with the limited licensure. It may make sense. I guess the reason I'm pausing a little bit is without identifying specific documents, we're not providing a lot of guidance back to the issues committee to say, think about maybe document preparation I welcome thoughts. I also wonder if we want to wait and take this up again at the next meeting, since we've given less attention to the whole separate document preparation piece, given the hour. Why don't we do, let's do that. Let's wait, because we're going to meet to talk about regulatory sandbox. I want to think a little more about, and maybe have a more concrete proposal. If we're going to recommend some kind of document preparer, like there are in Utah or other states, right? That would A, be a statutory change, and B, we really do need to think about how it integrates with some of the other stuff we've done, as Jeff pointed out. So I think we need a little more thought on that before we crystallize any recommendation. So let's do that between now and the next meeting. We've accomplished a lot today, moving forward on limited licensure. So I'm proud of where we're going. I think we're moving in a positive direction. And I think we're going to be able to get a report back so that the Issues Committee and the broader state bar can move forward as well. So thank you, everyone, for the great discussion today. I think everyone participated, which I appreciate. A lot of good discussion. Anybody have any final comments, thoughts, questions before we wrap up? If not, I know it's 2 hours out of your busy schedule, so I appreciate it. I think it's important and worthwhile work. So thank you for joining us today. I'll see some of you in person in Asheville for the State Bar meeting next month, but we will have another meeting in about a month. We'll circulate dates where we take up some of the remaining items and continue focus on wrapping up the important work of this subcommittee. So thanks all of you for joining in. I appreciate it.
Thank you.
Great to see you.
Thank you, Mark.
Thank you, everyone. Thank you, Mark.